Welcome to our CFP exam prep discussion on estate planning, specifically focusing on the various methods to transfer property. Today, we're diving deep into this crucial topic that frequently appears on the exam. Let's break down the 5 main methods of property transfer. The first method is transfer by operation of law, which happens automatically when certain events occur. This includes joint tenancy with right of survivorship, where property automatically passes to the surviving owner upon death. Many test takers often confuse this with tenancy in common, which doesn't have the survivorship feature. Remember that with joint tenancy, all 4 unities must be present: time, title, interest, and possession. The second method is transfer by contract, which includes beneficiary designations on life insurance policies, retirement accounts, and transfer on death designations. A common mistake students make is assuming that a will can override these contractual arrangements. The truth is, these contract designations typically supersede what's written in a will. For example, if someone names their ex-spouse as a beneficiary on their life insurance policy, but leaves everything to their current spouse in their will, the ex-spouse would still receive the life insurance proceeds. Moving on to trusts, our third method. Trusts offer flexibility and control over property distribution while potentially avoiding probate. The key components are the grantor, trustee, and beneficiary. Students often struggle with understanding the difference between revocable and irrevocable trusts. A revocable trust can be modified during the grantor's lifetime, while an irrevocable trust cannot be changed once established. The exam frequently tests scenarios involving these distinctions. The fourth method is probate, which is the court's supervised process of distributing assets according to a valid will. Many students underestimate the importance of understanding the probate process. Remember that probate assets are those owned individually by the deceased, with no beneficiary designation or right of survivorship. A classic exam question might ask about which assets must go through probate versus those that bypass it. Finally, we have intestate succession, which occurs when someone dies without a valid will. Each state has its own intestacy laws determining how property is distributed. The exam often presents scenarios where you need to determine who inherits what percentage under intestate succession. A typical mistake is assuming that a non-legally recognized partner would inherit under intestate laws they wouldn't. Here's a practical example that ties these concepts together. Imagine a client has a house in joint tenancy with their spouse, a life insurance policy naming their children as beneficiaries, a revocable trust containing investment accounts, and a personally owned car with no beneficiary designation. Upon death, the house would transfer by operation of law to the spouse. The insurance proceeds would go to the children by contract. The trust assets would transfer according to trust terms, and the car would go through probate. When studying for the exam, focus on understanding how these methods interact and which takes precedence over others. Pay special attention to scenarios involving blended families, second marriages, and complex asset structures. These situations often appear in exam questions because they test multiple concepts simultaneously. Remember that contract designations and operation of law transfers generally take precedence over will provisions. This hierarchy of property transfer methods is crucial for success on the exam. Practice identifying which transfer method applies in various scenarios, and always consider whether the property would go through probate or bypass it entirely.